Dear learners, welcome to this module of ARPIT at IIT Delhi. Today we will be discussing e-resource management and licensing issues. Licensing is an integral part of e-resource management, and there are several dimensions of licensing. So, we have to understand complete the concept of how licensing governs the e-resource management and what are the implications. Before we go into the licensing part, let us look how ICT has impacted libraries and what kind of impact it is having on complete library resources and services and their delivery. Now, if you look at the point number 1, this is from collection to connectivity. So, earlier the emphasis used to be on collection building, on collection developing. Now, the complete focus has shifted to providing connectivity. Similarly, we used to own the resources earlier. There used to be ownership of print resources. From ownership, we have moved to accessibility. It has become more important to have access rather than being the owner of the resources. Similarly, the print resources used to be real. They used to be in physical format and they were available in the libraries. It has again gone to a virtual format where things are not available physically, but they are basically in virtual format. This concept has again moved from paper to pixel. So, again the entire concept of searching has also undergone a transformation. We used to discover our resources through catalog. Now, there are search engines. Similarly, if you look into print resources more deeply, then we find that there used to be fixed period of accessibility. You purchase print resources where you have accessibility from 9 to 5 or 8 or 9 to 10 depending upon your libraries. Online format, the accessibility is for all 24 hours. So, this is a major transformation where resources are available under a 24/7 kind of environment. Similarly, when we purchase print resources, there used to be no agreement as such, whereas under electronic environment, everything which is procured is governed by a written agreement. There has to be a proper written agreement, a licensing part to regulate the accessibility and other points. The print resources used to be free of any surveillance, whereas all online resources are about absolute surveillance, where all downloads, all viewing is being monitored, where all statistics are being generated, how resources are being utilized. So, that is kind of surveillance which is integrated with the usage of these resources. What are the major issues with regard to e-resource management and its licensing part? Let us look into these issues. So, let us start with the selection issues. So, earlier in the selection of print resources, there used to be complete independent kind of selection where you select a particular resource and then you can buy independently. It was a stand-alone kind of selection process. Under electronic resources, there is a bouquet system where you have to go for a complete bouquet and there is no title by title kind of choice available to you. There is no pick and choose, but you have to go for complete database. So, this process of buying complete bouquet, complete database makes subscription quite costly. Then there is the issue of duplicate titles. There is a lot of overlapping across the databases. For example, between ABI Inform and Business Source Premier, there is large number of journals which are duplicate overlap. So, we have to be very careful about these issues. Then there is pricing issue. Under physical resources, under print resources, there used to be fixed prices and we went to buy these print prices only. Whereas under electronic resources, there are no fixed prices, there are offer prices and basically prices have to be negotiated. And there are also prices which are based upon tier 1, tier 2, tier 3 systems, and there can be change in the tier also. If you are subscribing a resource under tier 1 kind of pricing, then it can be negotiated to tier 2 level pricing if there is some slight change in the profile of your organization. And acquisition or merger of publisher has created another kind of problems with regard to pricing, because companies are merging fast, they are being acquired by bigger companies. So, this again leads to some kind of complication where you have to renegotiate or you have to re-arrive at the prices. So, every license, whenever we buy some online database, whenever we acquire some online product, there has to be proper licensing, because we do not own this product, basically we have the right to access it. So, this right to access is governed by licensing. So, we have to critically look into the issues which regulate these licensing processes and what should be the component of these license. So, if we look, licensing grants permission to use instead of ownership. This is the basic point, that you have a license to access only and you do not own it. There are a lot of restrictions with regard to even usage, and what kind of restrictions are there, how your usage will be governed. So, we have to examine all these points carefully. As I said earlier, as we discussed earlier, that this is access versus ownership kind of issue largely, because the purchase of content will provide ownership, and it will also lease of content will take the form of access to content via an annual subscription. Basically, there are two areas where when you purchase, whether it is a permanent kind of ownership, only you have to pay some maintenance fees, or you are signing some agreement which provides you a lease of the content, which provides you access through some annual subscription. Then you have to define users who are the authorized user of this product, whatever database you have purchased. So, your license agreement should clearly identify authorized users, who are the authorized users, bona fide students of your institution, bona fide faculty members, researchers, other patrons of the institution, and alumni, sometimes guests who just walk in to use the resources. So, this has to be clearly defined in the license, otherwise it can lead to some complications. Then there is a question of off-site access. Large access is within the institution, it is through the network of the institution, but there are provision of off-site access also, there is provision of remote access. This has to be clearly defined in the agreement, what kind of access is being provided. Then what kind of authorization you have. Even the authorized users have certain kind of limitations, certain kind of provision through which they can have access. Whether your access is just limited to viewing or downloading, copying, printing and saving copy of research study. So, this has to be clearly defined in the agreement, that what kind of access, whether it provides you only viewing or even downloading, copying and printing is allowed or not. Then what kind of use, whether you are using for scholarly purposes, for educational or scientific research, teaching, private study and clinical purposes. So, these all sort of issues have to be dealt with properly. Even if you are using it for some clinical purpose, whether your system, whether your vendor allows this kind of usage or not, has to be clearly defined in the license agreement. Then there is a point of sending a copy of an article to another authorized user. So, sometimes licensing agreement do not allow this kind of privilege, whereby you can change some information through to some other user, or where even you can provide some kind of link to other user. So, this has to be seen what are the digital right management associated with the database. So, these have to be incorporated accordingly as per your requirement and your usage pattern. Then there are certain discovery tools available to you, which help you to access the resources in a more meaningful, more purposeful way. They discover the resources in a much faster and much integrated manner. So, you have to see in the license agreement whether your database, your product information product is linked with discovery system or not, whether it allows you to link your product with your discovery system which you are using. For example, if you are using EBSCO discovery system or any other discovery system in your library, in your organization, does the license allows you to integrate with the discovery system or not. So, you have to be very careful about this. Then there are fair use provisions of digital rights management of copyright. So, you have to also look into these areas, whether fair use is allowed or not, whereby you can integrate your database with some course packages, where you can download and you can make some print copies and then make part of this your course pack or not. So, this kind of permissions are there or not. So, this has to be again be a part of the licensing agreement and has to be carefully done. Then there is issue of interlibrary loans also, because libraries use this loan facility to a great extent. They exchange information from between other libraries and also borrow from other libraries, and also sometimes they provide on loan their own resources. We have to understand whether our licensing agreements, our licensing provisions permit interlibrary loan facilities to us or not, whether what kind of provisions are there, whether there are some limitations with regard to numbers, with regard to time you can provide the resources interlibrary loan system. So, you have to understand all these provisions and accordingly make the licensing agreement, make some changes and get these provisions incorporated. Sometimes some vendors allow this kind of facility, sometimes the vendor does not allow. So, this depends upon your own requirement, it depends upon your organizational systems. For example, JSTOR, Cambridge Journal online, do not allow a parent copy of the electronic resource. Now, we have to carefully understand all these provisions and get these incorporated as per our requirements. Then there are other conditions with regard to licensing, like maintenance fees and archival rights. So these are very critical areas of license where what type of maintenance provisions are there. So if you have to pay some maintenance fee for even for archival collection, if you go for archival collection, which is basically one time payment, so do you have to pay some maintenance fee to use this archival collection, or there is no maintenance fee? So you have to properly understand this component also, because sometimes this maintenance fee can be little higher and it becomes difficult to sustain it. So we have to be very careful and properly negotiate this clause with regard to maintenance fee. Then also perpetual access. So what kind of perpetual access is being provided? Are there some embargoes? Are there some limitations with regard to perpetual access? Then what kind of archival rights are being provided? So because different publishers, different vendors, different subscription agencies have different sort of provision with regard to these archival rights, with regard to perpetual access and with regard to maintenance fees. So we have to understand what the provisions are there with regard to all these issues and accordingly get them incorporated in the license. Then there are provisions with regard to governing law, renewal and non-disclosure of terms and conditions. These are very, very important area. Governing law basically means if there is some dispute between the service provider and your organization, how this dispute shall be settled, where this dispute shall be settled, in which court this dispute will go. So this is very important. Basically, most of the time the service provider, the product owner, the database owner uses his own code of his own country. Like if it is US publication, they will have it all these disputes settled in the US courts. So you have to be very careful about this, and you have to insist that the governing law should be of your own country where you are making use of resource from where the payments are being made. Because in case unfortunately if there is some kind of dispute between the two parties, then it becomes very important to have a dispute system at your place. Otherwise it becomes very difficult, and there are chances that it can lead to more complications. You have to be very careful that whenever you sign this agreement, you must see into it that what is the provision with regard to dispute and which court this going to be settled. So we must insist, and we all must insist, that all disputes should be settled in the local court. Then there is a system of renewal which sometimes is inbuilt. The subscription is renewed on its own as and when the term expires, and sometimes even you don't come to know that database, the information product has already been renewed on its own, and you are sent an invoice for its payment. So it has to be seen carefully what kind of provision you want to keep, whether it will be an automatic renewal or it has to be renewed only when you ask for renewal, when you send a communication in writing for its renewal. So this is again a critical component, because sometimes what happens, that database is renewed without your knowledge, without your even permission, and you are sent an invoice and you are not able to make the payment because of lack of funds or because lack of approval. So this has to be completely incorporated in the license, that there will be no renewal until unless there is a clear-cut communication from your side. Again, some vendors, some database companies, they are doing that, they don't disclose the terms and conditions because of certain provisions of their own country, where they have some business business issues, that being a company, being a business organization, they will not like to disclose some of the terms and conditions. So this is again a critical element of this licensing system, and you must insist that all terms and conditions should be properly disclosed, so that everything is upfront and you have complete knowledge of your product and what kind of provisions are there governing its usage. So there should be complete disclosure, and you should not accept any such clause which says that there will be non-disclosure of any terms condition. There is a provision with regard to amendment. What kind of amendment can take place in licensing terms of services and how these amendments can be worked out. So, this clause allows vendor to alter the terms of the license without notice and also allows the vendor to change the product without information. So, this is again a very critical element that we have to understand it, that what kind of provisions are there with regard to amendment of terms, so that your vendor, your service provider is not able to make any change in the terms condition without your permission, without your knowledge, without consulting your organization. So, this clause has to be properly understood and accordingly modified, so that whenever there is some change in the terms and conditions or amendment, it has to be done mutually, it has to be done through mutual discussion and not by the vendor on its own. Then there are issues with regard to usage like systematic downloading and unauthorized users. So, what happens when complete issue is on a specific topic which is relevant to research? So, normally systematic download is not allowed by the service provider, and whenever there is some systematic downloading, the access is denied. But at times you require complete volume, you require complete issues, all the issues of that particular volume, because you have to understand the entire concept in greater details. So, you have to at times go for limited systematic downloading. So, again it has to be part of your agreement that how this systematic downloading will be governed, what kind of limitations are there and what kind of exceptions will be there. These exceptions should be clearly defined, and sometimes very highly specialized journal relevant to a researcher has to be downloaded in its complete form, its complete volume. So, we have to inculcate these kind of provisions there, so that your access is not denied on flimsy ground, and if there is genuine research interest, this should be safeguarded. And what happens that whenever there is some systematic download, so the access is completely denied to the entire user community. So, this is very unfair provision when an individual makes some mistake inadvertently and you penalize the entire organization, you penalize the entire user community. So, you have to again be careful and make sure that these kind of draconian provisions make form of the licensing agreement, and there are well defined and there are fair exceptions to this systematic downloading kind of provisions. There are archiving issues, what kind of archiving rights you get and what kind of provisions are in your licensing. So, libraries make payment for list price plus e-content fee, and they use permanent use of resource should allow the library to copy data for the purpose of preservation and for creation of usable archival copy. So, this is again a serious issue, that once you make payment, you make a huge payment for access to resource, and then what kind of provisions are there with regard to archiving. This provision has to be again worked out, and balanced kind of agreement has to be done, whereby you have some archiving rights also, because once you make huge amount of payment, you have to ensure also that this access is available to you for all the time to come, for a long time. So, basically that can be done through archiving purposes only. So, this again has to be seen in a broader context, and there should be clear cut provisions in the license agreement, whereby there are these rights of archiving are available to libraries. Now, there are other issues like warranty, disclaimer, indemnity, etc. What kind of provisions are there with regard to warranty of platform through which the service is being provided, and if there are some other sort of devices which is being integrated with the e-resource management, like sometimes you buy e-resource through electronic devices like Kindle or Nook. So, whether these devices, whether these book readers are under warranty or not, these has to be again looked into, and what kind of the warranties are there and how much payments have to be made, for how long these warranties are there. There are always sometimes unreasonable kind of disclaimer, as is where is owner's risk and vendor cannot be held liable. So, all these disclaimers which are unfair basically and not reasonable disclaimers have also to be opposed, and seen to it that they do not form the part of the license agreement. Then there are clauses of indemnity, compensation. This also should be carefully negotiated, carefully examined from a legal point of view, and problem should be fixed as per the requirement, and there should be provision for refund non-accessible period if there is some indemnity kind of situation where some mishappening has taken place and the service has been affected due to some natural calamity or some other reason, some by way of some accident. So whatever excess remains has to be compensated, the remaining amount has to be paid. So these all points with regard to warranty, disclaimers and indemnity have to be seen very minutely and to be negotiated accordingly and should be fair. Now there is some provision with regard to evaluation of electronic resources, on what basis you evaluate, because it is very necessary to have a regular validation through evaluation. So basically we use statistics. So the entire system of generating statistics has to be robust, whereby the system generates very reliable usage statistics, and there is no tampering possible with the usage counter, the system. So it has to be very robust, very strong technically, and you must ensure that the reports are generated authentic and the statistics are also reliable. So what kind of reports are being generated, what kind of usage statistics are being generated have also been properly seen, like inconsistent of data, different formats, multiple clicking, inflated statistics. So these all points have to be seen. For example, if there is multiple clicking, then what kind of data is being generated. For example, when there are different formats of a same product, so what kind of format is being used and what kind of reports it is generated. So all these points have to be seen, and there are sometimes inconsistencies in the data then management system of that. So we have to be careful about all these issues, and we have to see that the interface which generates these statistics is reliable, is technically strong, otherwise it becomes very difficult to generate reports. Now in conclusion, I would like to give some suggestions with regard to this e-resource management and licensing issues. Basically, the system should be such, the licensing provision should be such that they recognize the intellectual property rights of the author and also the user. So there has to be basically a balanced kind of provision which recognize rights of all parties, all of users and the providers also. Then there should not be any provision, any unspecified provision in the agreement which can lead to some kind of complication at a later stage. Every provision should be in black and white, and nothing should be unspecified, everything should be clearly specified, so that all provisions are properly defined, all otherwise access becomes difficult at times and the service provider starts restricting the access. So this is very necessary that all terms and conditions are properly specified and their legal implications have to be understood. So what we can do is that we can take opinion from our legal experts, we can speak to our other legal sections of our institution and get this licensing agreement vetted by them, understand if there is any such provision which is not lawful, and we can get it amended. Who should sign this agreement? This is a very important issue. Whether as a librarian or head of the library, we should sign the agreement, or it should be signed by our head of the institution. So this is again important point, because if there is some problem with regard to agreement, if there is some problem with regard to licensing terms, who will be responsible for negotiating, for getting into these legal issues? This has to be properly understood, that who will be signing, whether head of the institution will be signing or librarian will be signing. So this has to be again discussed with the administrative authorities of the institution, and on the basis of their opinion only you should sign the agreement, or the head of the institution should sign the agreement. It has to be properly discussed within the administrative system of the organization, and everything should be properly approved by the organization before you sign the agreement. Else it can be difficult situation for you. Sometimes there is some problem, some legal problem, and because you have signed the agreement, So you may be asked to resolve it, and it becomes quite complicated. You enter into a legal battle which you are not able to fight. So you have to be sure while you sign the agreement that whether you have the capacity to get into these all contentious issues, or whether you should leave agreement to your organization, to the head of the organization, or to other administrative head. Then there are some provisions with regard to even with regard to litigation, or some regard to that if there is some sort of litigation, who will be bearing these charges, who will be bearing these travelling charges, or so again these have to be made clear, and these have to be very specified that in case of any dispute, in case of any legal issue, how these expenses will be met, who will be meeting the expenses, and what kind of system will be there to meet out this expenditure. Then even when there are issues with regard to this payments, with regard to this travel related to cost of providing training. Whenever we buy a product, we like to have some training at our site. So who will bear this training expenses, who will be bearing the travel charges of the trainers. So this has to be again clearly mentioned in the license agreement that all these travelling charges, all these training costs shall be met by the vendor himself or herself at his cost. Otherwise it becomes very difficult for us to meet these costs, because these are very regular, these are very frequent costs, and which we normally do not have budgetary provision for meeting this. So we have to make this very much clear. So these are some of the contentious issues with regard to licensing of these e-resources. So we have to understand these provisions comprehensively. We have to understand them, we have to understand their legal implications fully before signing this agreement. We have to make sure that all the interests of our users, all the interests of our organization are completely safeguarded, and if there is some requirement, if you feel that there are some unfair clauses in the agreement, we can get these changed. We must insist to change these clauses, otherwise it will become a perpetual problem, and even your access can be restricted. So licensing is a very serious matter. Licensing has to be understood by legal experts. So it will be very important for you to examine, to get the licensing agreements examined by your legal cell, by your legal experts in the institution, or from you hire some legal expert from outside and get the entire licensing vetted by these experts, so that everything is in place. Whatever money is being spent on subscription is well utilized, and there are no complications with regard to usage. So thank you very much. I hope that it has been useful to you. Thank you.